and I assume we'll get started here in a moment.
All right, ladies and gentlemen, we're delayed. I apologize for the delay. Leave it to the state elected officials to be running behind, wasting everybody's time. They don't realize that real people have work and things they need to do. They're not respecting regular people's lives. So instead of just letting you watch that boring ass screen, I figured I would come on and talk to you. I wasn't planning on coming on this morning, but rather than letting you guys sit here just watching that nonsense, I figured I would come on and at least chat with you. Good morning, Sean. Good morning, Puppy Branch. Good morning, Jeff. Good morning, Todd. Good morning. Hey, Ashcraft, how you doing? Welcome. I figured we would just kind of chat here a little bit until there's a whole bunch of rumors going on. And I'm wondering, and this is just totally my conjecture, I'm wondering if there's issues with the bill. So something that I didn't talk about last night, I'm going to say this, and there's absolutely no there's no credibility to this. Okay. And it didn't come from me. Last night, I heard from, and I'm going to tell you, I heard this from a chief of police. So full-time tier 1 guy, 20 plus years in law enforcement, contacted me and told me that he actually heard from a state representative that something fatal happened to the bill yesterday. Now, when we had our guests on last night, I didn't, and when we did the show last night, I didn't really get into that because I was not able to run that down. I did not hear that from someone at the State House. And while the person who told it to me is someone that I highly respect, and in the past they've provided me with a lot of good information, I just wasn't able to run it down with anywhere else. But I'm starting to wonder, there's been a whole bunch of weird things going on behind the scenes that I have been able to pick up on. And I don't know if you guys heard it or not, but right as I came on, they came on this screen. So the thumbnail that I put up, this is my thumbnail. I'll show you here for the screen. This is my thumbnail. Indiana General Assembly, State House Committee, Courts and Criminal Code, House Bill 1186 discussion. This is the thumbnail from the General Assembly. And they have this up on the screen. We're live. We're in with them now. Volume's up. And they actually came on and someone said, we are dealing with a few things and we'll be with you momentarily. Okay. Matter of fact, let me go back here and do something and refresh just to make sure that we're good. But this could be any number of reasons why this is delayed. I don't know. And I guess it's kind of wishful thinking. I'm kind of hoping. Let's see. Yeah, we're still waiting here. So let me show you here while we're waiting. I guess I'll tell you rather than show you. Let me see over here. Now let's look at this. So in room 156B, okay, yeah. So there's another committee meeting also today. And they are meeting. So it's not like it's not technical difficulties. The Elections and Appointment Committee is currently meeting, and they are currently in session. So it's not that. So they're not having technical difficulties. So that means Let me ask you this. Is there anybody or any of you that are watching this, any of you law enforcement officers have somebody in the room? Are there anyone from your department? Anyone from your departments that are in the room? Does anybody have the ability to contact somebody? Let me see if I know of somebody in the room.
Let me
Oh,
get
here we go,
everybody's
ladies and gentlemen.
attention on the committee.
I'm going away.
All right, there we go. We are going to start with forgo introductions and go ahead and start with House Bill 1006. Representative Jeter.
Okay, thank you. Good morning, everybody. So House Bill 1006 is our prosecutor funding bill. Some of you may have heard about. It's okay with you, Madam Chair. I'm going to walk through just the bill and then kind of talk about what the amendment changes to kind of lay the groundwork for everybody. So the heart of 1006 is it creates a public prosecution fund to provide assistance to counties on the pay of their deputy prosecutors. So the language is borrowed heavily, and the system is sort of borrowed heavily from what we use for the public defenders, the Commission on Court-Appointed Public Defender or court-appointed attorneys. And for participating in eligible counties, they can receive up to a 50% reimbursement on the cost of their deputy prosecutors. Now, just as a review, the elected and chief deputies are paid by the state, so this would be all the others. And it also really the requirements to qualify. In the original bill, we asked the Indiana Prosecuting Attorneys Council to set caseload requirements. In Amendment 12, which is the amendment I'm asking the committee to accept, we do change that to more of a salary benchmark. And the reason for that is obviously the fear that we don't want counties to feel incentivized to have to charge more crimes to get more money. So the Amendment 12 would change that condition to be one that's salary based. So if a county pays their deputies at least 55% of the salary of their elected prosecutor, then they would qualify for the reimbursement. A lot of the other conditions we really are going to leave to IPAC. We don't exactly know how much money will be appropriated to this fund, and so we want to give them the flexibility to get that money where it needs to go. And the second requirement is that to qualify, a county cannot have a non-compliant prosecutor, which we define in the bill, and we set up a committee to make those determinations and some due process safeguards in the bill. We worked really hard on that. I want to thank, IPAC and as well as all the public defenders for their input and work, and LSA. We did a lot of work to make sure we kind of steered clear of First Amendment issues. Of non-compliant prosecutor basically is one that announces their intention not to prosecute, sections of the criminal code, and then engages in a practice which does just that. We don't want to limit it just to the public statements because that had some First Amendment issues. So we looked at some of the cases down in Florida and other spots where prosecutors had been removed, and we tried to really be cognizant of that of the First Amendment issues. So that's the major part of the bill. Like I said, Amendment 12 really. And I should note. So in an effort to try to find some cost savings, the original bill did combine the Public Defenders Commission and the council. As we got into that, we really realized that was a much bigger lift, I think, than we could do in this bill. And again, I want to thank all the public defender groups for meeting with me and walking me through, and for IPAC. And I want to thank Andy Hedges. I think I gave him like 50 amendments. But we decided at the end of the day to take that out. I just want to say, there are about 5 public defender groups in the state, and they all do very important work and incredible work. I still think there's probably some cost savings we could realize in there, but it's definitely a much more complicated puzzle than we originally thought. So we want to be prudent on that. So Amendment 12 removes that merger, leaves them where they are, changes the caseload trigger to more of a salary requirement. We want the counties to have some skin in the game as far as what they're paying. And it also staggers the commission, staggers the terms of board members on the Public Defender Commission. I guess kind of an oversight when they were created, they all roll off at the same time, and they asked us if we could fix that. So that's also kind of an ancillary part of the bill. But again, this and it also the public defenders currently are reimbursed at 40%. This bill pushes them to 50% to match the prosecutors. And the goal here really is to help our counties retain their prosecutors. As you know, we've got a lawyer shortage, and as it currently stands, these lawyers can make more money going to even other state agencies, DCS, other parts. One of the examples I think of this the best. I represent a portion of Madison County, and in Madison County, they have because of the prisons that they have 3 state paid deputies, and the state paid deputies make about $30,000 to $40,000 more than the starting salary of a Madison County deputy, even though they do the same work. So, we got to let our counties compete for that talent. And so we're going to try to do that. And we'll see what kind of appropriation we can get. But I think it's a great step towards really investing kind of a generational investment in the criminal justice system, both public defenders and prosecutors, both of whom are necessary to maintain law and order. So with that, I'm happy to answer any questions.
You combined your amendment as well as the discussion, correct?
Yes.
All right. Do we have any committee discussion or questions about either? Representative Gore.
Thank you, Madam Chair. Representative Jeter, you said, let me scroll down to the non-compliant prosecutor portion of Amendment 12. You said that we're trying to avoid First Amendment issues by not basing the decision to conduct an investigation into a non-compliant prosecutor just based off perhaps a public declaration, but also a pattern of conduct thereafter. Is that right?
Yeah, I mean, the amendment, I don't think we can, it's probably not prudent to declare, to find a prosecutor non-compliant just because of something that they say. So really that finding requires also a pattern, but to your point, and if I misspoke earlier, I apologize, to trigger the investigation, a public statement, it requires an investigation. Again, if a prosecutor says that, we're going to take them at their word and we're going to investigate. If it's a report of a pattern, that's a little bit more, that's discretionary. That's a May provision for the IPAC committee that we're setting up because, again, we want them to be able to wade through, any frivolous complaints or what have you. We trust them to handle that.
Thank you. But what you're saying is that to then find them non-compliant, there must also be a pattern.
Correct.
Okay. Thank you.
Representative Pierce.
Yeah, just to follow up on the issue, Representative Jeter, I wonder how you would respond to those of us who might say, these prosecutors are elected in each of these counties and they each have different priorities, different ways they allocate their resources. And every 4 years, if they choose to continue in office, they need to get reelected and convince people that they're getting a job done for them. So why do we need this state mechanism to come in and I guess essentially punish the county by removing this potential new funding stream from anyone who has maybe a different set of resource allocations than other prosecutors?
Yeah, so I think I feel very confident that there's a difference between prosecutorial discretion and resource allocation and blanket refusals to enforce a certain criminal law. And I think that, I know that there's kind of an effort to blend those, and we try to not touch prosecutorial discretion, but at the end of the day, like these are state dollars. And I think that it's appropriate for us to outline, sort of condition them on our expectations. And these are our laws that we want enforced. And so, we're doing our best to make it only apply to those who make broad decisions that they're just not going to prosecute, certain crimes.
Representative Gore.
Thank you, Madam Chair. Representative Jeter, do you ever think there are times when it's more just to disobey the law? Or do you recognize periods throughout history when it has been?
Well, I think that's a dangerous slope to get down because then the question becomes who decides which laws are just. I mean, I would submit to you that that's our decision as the General Assembly. And whether you think a law should or shouldn't be, or that we should do a law differently, I think we would all agree that that's a decision that we should make and that a county official should not make.
All right. Any other questions? Okay. Can we take the amendment by consent? Okay. All right. We will start with Bernice Corley from the Indiana Public Defender Council.
Morning, Madam Chair, and to the committee. My name is Bernice Corley. I'm the Executive Director of the Indiana Public Defender Council. It's a pleasure to be here today. IPDC has no position on the now amended bill. However, I do want to thank Representative Jeter and the committee as a whole for the just adopted amendment that does away with the proposed merger. This amendment reflects a thoughtful approach to preserving the integrity and the distinct roles of the two committees. For nearly 50 years, IPDC has served as a vital resource for public defenders, providing training, support, advocacy to all attorneys who do this work throughout the state. Meanwhile, the commission, they serve a crucial role as well. They enhance the quality and the oversight of court-appointed attorneys across the state of Indiana. Keeping these two organizations separate respects that we each have a distinct function to serve, and while not compromising either by putting us together. Maintaining this structure, it affirms that Indiana is committed to the right to counsel and the provision of quality counsel to clients. So just want to say thank you again for this decision and this thoughtful approach.
Any questions? Representative McClure?
Thank you, Madam Chair. Bernice, are you familiar with the Dred Scott decision?
I am.
Could you give us a brief synopsis of it, please?
So the Dred Scott opinion is related to separate but equal usage of public transport and access thereto.
Any other questions? All right, thank you very much. Courtney Curtis from IPAC.
Thank you, Madam Chair, members of the committee. My name is Courtney Curtis. I'm the Assistant Executive Director for the Indiana Prosecuting Attorneys Council, and we rise in support of House Bill 1006. I want to say thank you to Representative Jeter for this thoughtful approach on this widespread issue. We've been before this committee before in previous sessions to talk about the prosecutor shortage, and spoiler alert, it hasn't gotten any better. If we were to borrow the caseload standards of the Public Defender Commission, the Commission on Court-Appointed Attorneys, we would need over 400 prosecutors, additional prosecutors, in order to fill that void. We are currently serving at about 67% of what we would need, and some counties are serving as low as 35%. There are 26 counties in Indiana with job listings right now on the IPAC website, and applications to law schools applications to prosecutors' offices are down dramatically nationwide. In fact, there was an article published in the William and Mary Law School paper called The Prosecutor Vacancy Crisis, and it talks about how this is a crisis nationwide. It's because prosecuting is a hard job. It's very emotional. You will see people and meet people when they're in the worst conditions of their lives, just like police officers. It's not as dangerous for us, but it is extremely emotionally hard-hitting and requires a lot of thoughtful work, and it is not a 9-to-5 job. The other reason that prosecutors are losing out on fresh blood from law school is because of salaries, and that's what House Bill 1006 addresses. House Bill 1006 allows us to stop the bleed. We're losing a lot of our higher end, more experienced prosecutors to make more money elsewhere. And then we are not getting those law school applicants coming in to give us fresh blood at the bottom. It currently, if you are a full-time law student at IU McKinney, it's $30,000 and $30,240 for your tuition only. When I was in law school, not to date myself, but I took out $20,000 per year in loans to go to school and support myself. That's no longer viable even to just pay for tuition. And yet our 611 full-time deputy prosecutors are making a mean of $89,514 a year, or a median of $87,000 and change. They are attorneys. They're not in it to make millions of dollars. They won't make millions of dollars, and they know that, but they aren't making enough to support their families. If you compare that to DCS attorneys, the median of the lowest grade of a DCS attorney is $99,411. The median of a highest grade is $123,253. This bill helps public defenders too. Obviously, they will get up and talk about their own challenges. But public defenders are facing some of the same crises as prosecutors. And so this bill is thoughtful in that it increases their percentage of reimbursement. But also when prosecutor salaries, deputy prosecutor salaries rise, then the public defender salaries rise as well. Another portion of this bill in 1006 establishes a special prosecutor unit. There are a diminishing number of senior prosecutors in Indiana. Senior prosecutors are those who can be appointed as special prosecutors on cases where the elected prosecutor has a conflict. There are a number of reasons why it's difficult to be a senior prosecutor. They don't have staff. Senior judges, if they work a certain amount of hours per month or per year, are eligible for benefits. That's not true for senior prosecutors. So there's also just less to attract them to that. So we have these offices that are already short-staffed, providing services for one another as special prosecutors. This unit that would be established would also help when big cases come to small counties as well. When you have a case that is enormous, that's going to take up the entire resources of your office, then rather than calling in a special prosecutor, an individual elected could also avail himself or herself of the special prosecutor unit by asking a prosecutor from that unit to come work for the office and provide assistance on particular cases. This was mentioned by Representative Jeter as a generational shift and focus on the public safety. There were the top three concerns for Hoosier voters as we headed into this legislative session were education, mental health, and public safety. Public safety is not just prosecutors. It does include public defenders, but on the prosecutor side of it, we can't ignore crimes when they're committed. We can't ignore cases when they need to be filed. We can't ignore victims when they need to be consoled or when they need to be reminded of what their rights are. We can't ignore trials when they're set. And we are frankly bleeding out. And so for Indiana to take a look at what is happening nationwide would be something to be proud of, frankly. And so we rise in full support, and I'm happy to answer any questions.
Any questions for Courtney Curtis? Representative Gore.
Thank you, Madam Chair. I think we heard a synopsis of Plessy v. Ferguson. Are you familiar with Dred Scott?
Somewhat.
I just want your elevator version of what that was about, if you could.
Dred Scott, in my opinion, was about the worth of how many persons, or excuse me, how much of a fraction of a person a slave was to be considered as part of the census.
Yeah, essentially describing them as property.
3/5 of a person, I believe, sir.
Codifying them as property.
Yes.
Thank you. Could I just a few more that are perhaps more relevant, Madam Chair?
Can we stick to the topic of the actual bill when we're asking
gonna
our
bring it
questions,
all-
or get to
Yes,
your point?
Yes,
please?
Madam Chair. Do you know how many marijuana-related charges Ryan Mears filed last year?
I do not.
It's 1,100. And does IPAC still believe that prosecutorial discretion is inviolable?
Yes.
Okay, thank you.
Representative Pierce.
Thank you, Madam Chair. Following up on that, I wanted to talk just about the mechanics of this review board.
Yes, sir.
And so the way we're writing the statute, it says upon receipt of information that public declaration had been made by a prosecutor, then that would kick off, I guess, an investigation process. So
Yes.
in what form is this information going to be? Could a member of the public call you up and say, hey, I heard the prosecutor say he's not going to prosecute any of these things in a rotary speech or something? Or what do you see as the method by which the board is going to get information?
Because the bill does not speak to that, I think that yes, technically that would be possible. There is a function that allows for that in the special prosecutor language currently that's already in code where anyone could request a special. So I believe that is probably why this is not more prescriptive.
Okay, so some information comes in from somewhere suggesting a prosecutor is categorically refusing to prosecute something, and then the 5 board members have to begin an investigation. Is that the next step?
That's how I read it.
Okay. And does that board have any investigators on staff or anyone who's trained in investigations? I guess maybe you're tangentially, at least as a prosecutor, but help me educate. Do you think they have does the board have the investigators or the resources to actually investigate that? That's what I'm trying to figure out.
They don't have any law enforcement officers that are working for them in their capacity as a board. Investigation, though, can have a broader term. This isn't a criminal investigation. So I would interpret investigation to be look into.
Okay. So those board members who are the other prosecutors are going to look into it. And then I guess they tell the prosecutor who's the target of the investigation that, hey, we think you may be categorically excluding certain crimes from prosecution. And then there's a certain number of days for that prosecutor to kind of respond and defend themselves in some way.
Yes.
Okay. And then the board, at that point, after they've gotten information, I guess they will make a determination as to whether the prosecuting attorney is non-compliant. And then once they make that determination, then they tell I guess the comptroller not to give that county any money. Is that kind of the process at the end there?
Yeah, not to give money from the
From that-
prosecutor fund that's created
That we're
by the bill.
creating,
Yeah.
right?
It doesn't
Okay.
withhold current state monies that already flow to that county.
Okay. And so in the statute, I just want to make sure I'm not missing it somewhere, but I don't see anything where the prosecutor could appeal the decision of the board before the order is sent to the notification, whatever you describe it as, to the comptroller saying they no longer have access to this fund. Is there any appellate ability? Can the prosecutor, if they feel the board got it wrong or didn't pay attention to some important evidence or something, is there any place in the statute where they can go to seek to have that overturned?
It does not preclude them from filing for an injunction in a court.
Okay. But what would be the grounds
So
in the statute?
when we were talking, well, I wasn't talking, but when Representative Jeter was talking about case law coming out of Florida, that's what occurred. So the Constitution in Florida, it's different from this, but the Constitution in Florida allows for the governor to remove any elected official who is not subject to impeachment. And then that happened to the Tampa state's attorney, and the Tampa state's attorney filed a lawsuit in the court saying that policy had not been enacted appropriately. There was nothing in the Constitution that says you may file in the courts, but if an individual believes that a law has not been applied fairly, then the courts are always open to that person.
Okay, well, I suppose you could try to make a constitutional argument under the state or federal constitution, but it seems to me if the statute doesn't give you any right of judicial review or a pathway to some other body to hear an appeal from the board, I'm wondering what the court would hang its hat on. If they didn't find a constitutional issue or maybe some other statute or something, because we're not giving any right of judicial review clearly within this statute. Would you agree? There's no.
I would agree that that's not clearly stated. I would just also agree that the right of judicial review is not stated in any civil statute, and
Okay.
yet the civil courts are full.
Okay. And then we would just have to figure out whether that's a de novo review by the judge or whether they're going to give some kind of deference to the board, right? We're all silent in the statute about that as well.
That's correct. The bill
Yeah.
does not speak to
So
that.
the judge can have to figure that out. So I'm wondering with some of that ambiguity in there, I mean, what does the prosecuting attorney council generally think of this idea? Do we need oversight of prosecutors because they're not doing their jobs the way we'd like them to?
Prosecutors have stood before you on multiple sessions and said that we would love to keep our discretion and that we do not want to have a review. However, if this body wants the prosecutor to be reviewed in some way, we would rather handle that ourselves than have some oversight from someone outside of prosecutors.
Okay. So let me just ask the question a little more precisely. Do you think there is some oversight mechanism needed because some of your members are not properly doing their job?
It has never been our position that we would ask for some oversight.
Okay. All right. Thank you.
Representative Zimmerman.
Thank you, Madam Chair. Courtney, is it fair to say that even if a complaint or some kind of notice is sent to this review board, that this 3-member board may decide, prosecutor still has the discretion, we're not going to find him non-compliant? Is it fair to say there's still that discretion on behalf of the board? Even if the general, you've got this declaration, I'm not going to enforce this law, I'm not going to prosecute this law. IPAC could still review it and then say, that's okay, no problem. There's still the discretion to say, use Ryan Mears since he's the one that keeps getting brought up. Ryan Mears, you can still prosecute. However, your discretion, you still have it. We're not going to withhold your funding.
I believe by the way that it's written, that if the numbers that are given by Representative Gore were correct and the board felt that then was not a pattern of conduct,
Thank you.
Representative Bauer.
Thank you, Madam Chair. Courtney, in this bill, it includes staff attorneys at IPAC to be included in PARF. Are public defenders included in that?
No, and the only the reason for that, although we've filed legislation hoping to put public defenders into PARF. The reason for the inclusion is that the special prosecutor unit, in order to get individuals to want to be part of that and not be county prosecutors, then that would draw them to the special prosecutor unit, and then not having some attorneys within IPAC with different benefits from other attorneys within IPAC.
Okay. And then you mentioned that this will increase the salary of public defenders, but it doesn't necessarily include that. You're thinking that it will naturally happen.
So I'll let them speak on it, but there's pay parity. So if you have a public defender commission county, and you have a public defender who is similarly situated, they have similar years of experience, they're doing similar work, then the county is not supposed to pay the deputy prosecutor more than that public defender.
Okay. Thank you.
Representative Gore.
Thank you, Madam Chair. This is very serious, Courtney. Don't you think PARF is a silly word?
I could
That's not
find
really my
better
question.
words.
Okay, so Section B of the non-compliant prosecutor section says upon receipt of information that they've engaged in a pattern of conduct that reflects a refusal, yada, yada, yada. I know that Marion County has a team of deputy prosecutors that are having pretty good success in charging and getting convictions on dealing causing death. But I know that that's a really tough case to prosecute, and many counties don't charge it. Is that a fair assessment?
I'm not sure.
Okay. That's what I've heard. And I'm just wondering, just using that as an example, let's presume I'm right there for a moment,
Sure.
recognizing I might not be. If these counties have, and their prosecutors have made a determination that it's a difficult case to try for myriad reasons, and so they don't do that, does that fit under engaging in a pattern of conduct that reflects a refusal to prosecute a criminal law? I guess I'm saying, is there a practical issue here with, for very valid reasons, they might refuse to prosecute a criminal law enacted by the General Assembly, but I don't see language that really would protect that circumstance. Do you have any thoughts on that?
I'm not sure what language I would craft to protect that circumstance. I think that we would say in that circumstance, you're evaluating the facts of that case, which is what a prosecutor is supposed to do.
Oh, and I agree. I just, because it's a may provision in that section that they may receive receipt of the information and may conduct an investigation. I just, I feel like that would be unnecessarily burdensome to that particular prosecutor. I'm not saying it's likely to happen. I'm just saying that, that would seem unfair to what I've been told is the vast majority of prosecutors who, for very valid reasons, don't choose to charge the crime I mentioned, I guess is what I'm thinking. And that's not a question necessarily. I'm just a concern.
Representative Shackelford.
Thank you, Madam Chair. So my concern is with the Prosecutors Review Board
Yes,
and
ma'am.
looking at the balance between political parties. Now, when you have 3 that can be the same party and 3 represents a quorum out of 5, do you fear that politics can play in some of this decision-making?
We would support language that would require, and I think in some iterations, there's been language where, so I think there has been some language that required the quorum to still include both parties, and I believe that that's potentially just an oversight in this one, but we would support an amendment to reflect that.
Okay, to make it more politically balanced.
Yes, ma'am.
Okay, thank you.
All right. Any other questions? All right. Thank you very much. Derek Mason from the Commission on Court Appointed Attorneys.
Thank you, Madam Chair. Derek Mason, Executive Director for the Commission on Court-Appointed Attorneys, commonly referred to in the criminal justice sector as the Commission. I rise today to support House Bill 1006 as amended under Amendment Number 12 and hope to work with you to address any remaining issues as the bill moves forward. We are grateful to the committee for eliminating the language to force a merger of the Public Defender Council and the Commission on Court-Appointed Attorneys, because not only were there no overt savings to a merger, and while we understand that the legislature currently has chosen to establish IPAC's reimbursement process all within one agency, we do believe that our existing separation of the regulators from the regulated is important, as is ensuring the ability for public defenders to have a strong voice within this body. We are also grateful for the amendment to make changes to how counties will qualify for reimbursement under the newly created Public Prosecutor Fund. The bill as amended does not require compliance with caseload standards to receive the state reimbursement. We are concerned that tying reimbursement to caseload limits, as mentioned by Representative Jeter, would potentially encourage increased filing so as to force additional resources for for prosecutor county offices, which would increase jail populations, increase public defender appointments, increase judicial caseloads, and ultimately raise costs in all of these areas. And we appreciate Amendments 4 and 5 and their attempts to address those issues as well. While the language as amended would allow IPAC to set caseload standards, it at least does not require it. The practical effect of the current language helps address the attorney shortage in Indiana, excuse me, especially those in the public criminal justice sector. Increasing prosecutor salaries will mean significant new contractual and salary improvements for public defenders in the currently 68 counties that participate in the Commission's reimbursement program. The increase in the bill to 50% reimbursement for counties under the Commission's reimbursement program is crucial so that counties are not encouraged to withdraw from the public defender reimbursement program. This would require an additional augmentation, of course. I know if it goes to Ways and Means, we would address that there. This bill expands eligibility for participation in PARF, as has been discussed, specifically as it relates to IPAC staff. And as you may recall, the House both passed enabling legislation and fully funded chief public defender and state public defender agency participation in its budget in the 2023 session. We hope that as this bill continues in this process, additional consideration can be given to at least include chief public defenders. We believe that option is critical to recruitment and retention of these county positions that are so important to effective and efficient public defense. And then finally, talking about our commission membership, we generally appreciate the language prohibiting certain individuals from serving on the commission to avoid conflicts of interest. Most of the amended language is very similar to the prohibitions on county public defender boards. We do have some concerns with the more expansive restrictions included in this language and hope that you will be amenable to some alterations as the bill moves forward. As one example, we have found the judges appointed to our commission to have been crucial in communicating with their fellow judges who are not in the commission and are currently in charge of the public defender system in their county because of the way Indiana historically has operated. Communicating with them and assuaging their fears about joining the Public Defender Commission standards and guidelines in exchange for reimbursement. And also, judges on the commission have been very helpful in rectifying instances of judicial interference in public defense issues statewide. Sometimes judges just want to listen to other judges, as you may know. We hope we can continue to discuss this as the bill goes forward. Finally, thank you as well for the amendment to stagger the terms, as Representative Jeter mentioned. We believe it was an oversight that attempted to put some consistency in state commissions that contain legislative members. We believe the amended language keeps the consistency, but prevents all of our members' terms from expiring at the same time, thus losing a lot of institutional knowledge potentially. So in sum, thank you for the amendment changes. We believe the bill has been significantly improved. And as I said, we hope to continue to address additional issues as the process moves forward. Thanks to each of you, and of course to Representative Jeter for your generous time and being open to suggestions. And thank you, Madam Chair. And we respectfully request a vote of due pass as amended.
Any questions for Mr. Mason? All right, thank you very much.
Thank you so much.
Jeremy Gooch from the Chief Public Defender Association.
Morning, Madam Chair. Hiding back in the corner. Members, my name is Jeremy Gooch. I am the president of the Indiana Chief Public Defenders Association. I've been honored to be the public defender out in Henry County since 2017. Representative Bauer, you stole my thunder a little bit. Our request is very simple. In looking at section 11 of the introduced bill, which would be page 13, it does add IPAC staff attorneys to PARF. We would ask that you consider, in looking at that particular measure, adding chief public defenders and chief deputy public defenders to PARF. Our basis for doing so, and frankly, is looking at balance. And if that idea does sound familiar to you, you could take a look back at House Bill 1605 in 2023, which on February 20th of that year passed the House by 94-1. Every one of the members, Madam Chair, you were co-author on that bill, that are sitting here today that were sitting in February 2023 supported that legislation. So we would ask that you give us consideration along with IPAC staff attorneys. And with that, Madam Chair, I'd be happy to answer any questions.
Any questions? All right. Thank you very much.
Good. Thank you.
So all those signed up to testify. Representative Jeter, would you like to close?
Yeah, thank you, Madam Chair. Appreciate the committee's thoughtful discussion. I do want to again thank the public defenders and the prosecutors for their work, on the bill. And I appreciate the committee's comments. I think we got the bill to a good spot. I think anytime a situation like this where you could have, I think it's important to remember that IPAC's made up of all the elected prosecutors in the state, and they elect their board. It's sort of the bedrock of democracy. And so I trust them to be able to police their own and to know legitimate complaints from non-legitimate complaints and to protect prosecutorial discretion. I can't think of a body that would do a better job at that. So I think it's at a good place, and I think it's appropriate for us to condition state dollars on the proper following of the law and prosecution of the laws as they're written. And so I'd ask for the committee support.
All right, any committee discussion? Representative Pierce.
Thank you, Madam Chair. I appreciate Representative Jeter being very careful and deliberate in his approach to the public defenders and how to streamline that potentially and have some efficiencies for the taxpayer. So I appreciate the fact that he's going to take a little bit more time to consider that issue before pushing something through. So that's positive from the amendment. And I also think it's good that whenever we can help our local elected officials or local units with the tasks that they're given to do. So that's a good thing. Although I'm pained because I don't think I can vote for the bill with this stuff about the non-compliant prosecuting attorney, because I just think that it kind of puts us on a glide path where we're signaling that there's some kind of problem that's at such a significant level that we have to start having some mechanisms for it. And who knows what someone will want to do next year beyond just denying a county access to a fund because the decision's made by their prosecutor. So I'm not going to be able to support the bill with that provision in it, because, we have to remind ourselves that, the job of prosecutors is not just to put people in jail. The job of the prosecutor is to do justice, and you have to have full discretion, and you can't feel like you have people, other than the voters who will pass judgment on your fears, that you're going to have, this board from on high kind of looking over your shoulder and potentially hauling you in. So I'm going to have to vote no on the bill.
Any other discussion? Representative Core.
Thank you, Madam Chair. The reason I brought up Dred Scott is because it was a Supreme Court decision that essentially codified that Black people were property, and it upheld the Fugitive Slave Act. And it's perhaps the greatest stain on the American legal system in its history. And of course, the people who upheld the notion that Black people were actually people at that time were violating the law. And we all recognize now that they were really the ones upholding justice. And a few years ago, this committee heard a bill about decriminalizing cannabis, and that took a great amount of courage and a great amount of political will and capital. And now I find that we want to penalize potentially my duly elected prosecutor, essentially because he agrees with many members of this body that perhaps the simple possession of cannabis should not be criminal. And to be clear, we would be doing this based solely off of his statements. We haven't really addressed the First Amendment issue. If he chose to synthesize his position on cannabis just so it was more digestible for his constituents, that's his prerogative. And of course, he still prosecutes marijuana crimes and he reviews them individually. And you may say, well, that's a good reason why he'll get off the hook after we drag him in and make him explain all these things. But the point is that it's just not necessary. And finally, you know, the majority, and by this I mean Republicans, though not anybody, not any individual members here today who I enjoy working with, often denigrates my city for its, you know, quote unquote, rampant violent crime. And so I guess our solution is that because my prosecutor doesn't file as many marijuana cases as we want, perhaps we'll strip his funding and further subject my constituents to be victims of violent crime or in some way not get justice. Now, because I know that Prosecutor Mears does his job well, follows the law, and is unlikely to end up being subject to this, frankly, unnecessary provision, and because the rest of the bill has some really good parts, I'm going to go ahead and vote for it. But the non-compliant prosecutor division provisions are, I really think, are asinine, and I wanted to mention that.
Representative Sturwell.
Yeah, I wanted to thank Representative Jeter for his thoughtful consideration on the commission language, kind of avoid some issues there, and I appreciate that. And I think it keeps it in line with what their what the membership's goal within the commission and the council, what their duties are. So I appreciate that consideration.
Representative Bauer.
Thank you, Madam Chair. My question would be to the author of the bill if he would be willing to take some of the suggestions heard today to add language to include chief PDs and assistant chief PDs or PD commission attorneys to PARF.
He doesn't necessarily have to answer that. He can if he want to. It's up to him.
I'm happy to answer. I know there's a bill in the Senate that does that, Senate Bill 416, I think, but I'm always happy to look at that and try to make the bill better.
All right, any other discussion? Can I have a motion, please?
Move to pass as amended.
Second.
Representative McNamara,
Yes.
Representative Gore,
Yes.
Representative Bauer,
No.
Representative Pierce,
No.
Representative Shackelford, Representative Meltzer,
Yes.
Representative Zimmerman,
Yes.
Representative Ireland,
Yes.
Representative Jeter,
Yes.
Representative Bascom,
Yes.
Representative Sturwald,
Yes.
Representative King,
Yes.
Representative Bartels,
Yes.
10-2.
We're going to hold this bill open for Representative Shackelford to come back, hopefully today. If she does not get back, we'll go ahead and close it with the vote of 10-2. Okay. Next up is House Bill 1114. Representative Zimmerman.
Thank you, Madam Chair, and members of the committee for your consideration of House Bill 1114. As the bill is introduced, it seeks to address a gap in the law. Currently, if you drive with a suspended license and your driving with a suspended license results in the death or catastrophic injury of another person, you can be charged with a level 5 felony. However, if you operate without a license and your act results in the death or catastrophic injury of another, the penalty for that's either a C misdemeanor for a first-time offense or A misdemeanor for a prior unrelated conviction. What this bill does is it takes the currently existing driving while suspended statute, the penalties for that, and it puts it in the operating without a license statute. This is a constituent-driven bill. I know that there was a constituent of mine. His name's Brad Kastner. He died in an automobile accident on his way to work in March of 2024, shortly after session adjourned last year, and he was killed in a motor vehicle accident, and the other driver that crossed the center line into Brad's path was driving without a license. And I think it's asinine, Madam Chair, that there is this gap in the law. We can't bring Brad back or anybody else back that has died from a motor vehicle accident where the other driver was operating without a license. But this bill just seeks to close that gap so that this doesn't occur in the future. With that, I'm happy to answer any questions.
Representative Pierce.
Yes, Representative Zimmerman, on that tragic case you just mentioned, was that driver charged with any other violations?
No, there was an investigation, Representative Pierce, and I will not speak for the prosecutor in that county, but in his review of the case, he decided not to charge, reckless driving or reckless driving resulting in death, anything like that. All that he found probable cause to charge was operating without a license.
Okay. Because the reason why I ask that is, I mean, whenever I look at these kinds of bills, I always ask myself, well, if you've got someone who's driving negligently, recklessly, maybe under the influence of, alcohol or narcotics or something, there's a lot of law out there that we have on the books that you can use to punish those people. And so when I just look at this bill in isolation, what I see happening here is you're taking a situation where a person who doesn't have a driver's license and is driving, if they're in an accident and we have some bodily injury or death, something happens there, it's like the way I read the statute is we don't really particularly care, whether that was just a tragic accident or whether there was some bad act on the part of the person driving because maybe they were drunk or something. What we're essentially saying is because you don't have that piece of paper or whatever, that license in your wallet, we're going to elevate all this stuff up. And I'm just wondering, I guess the question for you that I have is it seems to me like it might make more sense to essentially say, okay, you got one issue of are people getting their proper documentation to drive, they're getting a license, and figure out what the penalties for that. And then if you have people involved in accidents, then you have to ask yourself, was that just a legitimate accident? Was there negligence? Was there recklessness? Did they knowingly drink? I mean, you can look at all the other laws and decide whether or not, just as the prosecutor did, whether they should be charged for something more. And so why wouldn't we want to just to approach it that way, as opposed to saying the mere status of being an unlicensed driver now causes you to get higher penalties?
Well, Representative Pierce, I appreciate the question, but I think it's, as I said, it's asinine that if I drove on a suspended license and my act of driving while on a suspended license, and it resulted, let's just say it resulted in serious bodily injury, that's a level 6 felony under our current driving while suspended statute. But under our operating without a license statute, the only offense, if I didn't have a license, would be a C misdemeanor or A misdemeanor if it was a subsequent offense. I would agree that prosecutors should have the discretion to investigate those allegations, and if there's enough to charge reckless driving resulting in death or operating while intoxicated resulting in death, then that's what those crimes are on the books for. But this bill just seeks to address those gaps where, in the case I was discussing, there was no intoxication, there was no evidence of reckless driving. The the driver, my recollection is the driver veered over to the center line, rammed head on into another, and that accident resulted in the death of another person. And there is no, in the prosecutor's opinion, when he was charging this case, he decided there was not enough to charge reckless driving. And so all that this individual was responsible for was a Class A misdemeanor operating without a license. And that operating without a license resulted in someone's death.
So you're driven by the desire to even up driving without a license along with driving with a suspended license. And I'm wondering, if you're driving with suspended license, haven't you already been adjudicated to have committed some other kind of previous offense? So you can be suspended for example, if you're a drunk driver, right, you can have your license suspended. If you've committed previous motor vehicle crimes, that could lead to your suspension. Whereas if you just don't have a license, you may have, maybe you're a libertarian, you just don't want to go through the process, or maybe you can't go through the process, whatever the issue is, seems to me that's a little different than if you had your license suspended because you had been convicted of drunk driving or some other kind of driving offense, or you had so many violations that you got suspended.
In response, Representative Pierce, what I'd say is you can have your driver's license suspended for not paying child support if you've got there's a court-ordered judgment against you in a civil action that the judgment holder can send it to the BMV, and that can result in a suspension of your license. So, there are more ways to get a suspended license than just repeat offenses of drunk driving.
Representative Bauer.
Thank you, Madam Chair. Just some clarity, if you would, with the example that you gave in your community. You said there were no charges filed against that individual?
There were charges, but the only charge was operating without a license.
Okay. And so in your view, do you feel that justice was served?
No, I don't. I mean, as I say, prosecutors have discretion to charge. And if you're in the criminal justice system, you know that, a lot of times you can get charged with, you can get charged with a level 5 felony. But as a result of plea negotiations, it could be pled out as a level 6 felony. All this bill seeks to do is give the prosecutors discretion. If they want, if they wanted to charge level 5, they could. That doesn't mean that this will result in any more level 5 felony convictions. It's just giving prosecutors the tools to use if they decide there's enough to charge it.
And then, if I may, Representative Pierce gave some examples of individuals who might drive without a license. In this situation, why did that driver not have a license?
I can't speak to that.
Okay.
He didn't have a license.
Any other questions? Okay. Would you like to discuss amendment number 4?
Thank you, Madam Chair. Amendment number 4 is a little bit, it's a lot of an amendment, but I'll go through it as best I can. But the first couple pieces of the amendment are adding new offenses of fraud involving a motor vehicle certificate of title and fraud involving a motor vehicle registration. And if you commit those offenses, it's a Class A misdemeanor or a level 6 felony. If you use a business or nonprofit organization to commit or facilitate the offense, or the offense involves an application for title or registration of at least 2 or more vehicles. And the motivation for this, there was the biggest motivation that I can think of, Madam Chair, is there was a case in Clark County where a couple registered 29 LLCs over a number of years for the sole purpose of allowing folks who have no ability to get a driver's license or refuse to get a driver's license, the ability to register a vehicle through the state of Indiana. And what the amendment tries to address are those situations, Madam Chair. That's section, or the first section 1, section 2 of the amendment. And there is similar language as well for if you apply for or receive a driver's license with the intent to transfer a driver's license to someone who's not entitled to a driver's license, you commit fraudulent transfer of a driver's license as an 8 misdemeanor. There's also language in the amendment, Madam Chair, that if you operate a vehicle without valid driving privileges and you're involved in a motor vehicle accident for which you are at fault, then that the individual that's at fault shall pay the deductible for the motor vehicle accident for the insurance policy of the other that's not at fault. And then lastly, there's language in the amendment that if you are pulled over, arrested for, or charged with operating without insurance, operating without a valid certificate of registration, or operating without valid driving privileges, that law enforcement shall impound the vehicle unless there is someone in the vehicle that possesses or that has valid driving privileges. I'm happy to answer any questions.
Questions? Okay. There's no questions. Can we take it by consent?
Consent.
Okay. Okay. Can we take a, those who are in favor of the amendment, please say aye.
Aye.
Opposed? No. Ayes have it. All right. Interestingly enough, nobody signed up to testify on this bill. So, Representative Zimmerman, if you would like to have any
Madam Chair,
closing
I
thoughts.
will say that my constituents are here. They would like to, they may not have known how to sign up to testify.
Okay.
Kendra Kastner's,
Okay.
and I can have her fill out a form.
That would be appropriate.
Sure.
There might be a form when you're done speaking. Please fill that out and let us know. But tell us who you are, where you're from, and go ahead.
My name's Kendra Kastner. Brad Kastner was my brother. I want to thank you all for giving me the opportunity to speak to you today about why this code, Indiana code, should be revised. Like Representative Zimmerman said, on March 26, Brad was struck and killed by a man who was driving without ever receiving a driver's license. He was on his way to work in Seymour, Indiana from his home in Holton, Indiana. He was almost to work when a Chevy Trailblazer crossed the center line into Brad's lane and hit him head on. He was lifelined to IU Methodist Hospital. We were told that he suffered an unsurvivable head injury. He passed away the following day. He was only 27 years old. He was kind, adventurous, smart, hardworking. He worked as a laborer for O'Mara Construction. He was a talented ATV racer. He started racing in 2020 and won multiple championships throughout the years. My favorite memories come from the weekends we spent watching Brad get to do what he loved to do the most. Our family wanted the person that did this to Brad to be held responsible. We met with the prosecutor over his case, and he told us, like what Representative Zimmerman said, that there was nothing under the Indiana code that he could be charged with other than driving without a license, which, as Zimmerman said, is a C misdemeanor. And if any subsequent offenses are a Class A misdemeanor, this person had been charged twice previously for driving without a license before this incident. He was giving pretrial diversions both of those times. So this meant that he would only face a Class C misdemeanor, resulting in up to 60 days in jail, 30 days time served. This was extremely difficult for us to accept. He was just driving to work. He did absolutely nothing wrong. He was taken away from us by someone who should not have been on the road. This person is only going to serve 30 days in jail, but we will be without Brad for the rest of our lives. So we are just addressing that the gap in the law concerning operating a vehicle without a license be addressed with adding the Class A misdemeanor, level 5 and level 6 felonies. And an individual who drives without a license and causes a death should be held accountable under Indiana law. Our family struggles every day accepting the fact that the person who took Brad away from us will never face justice. We do not want any other families to experience the anger and heartbreak that results from not getting justice for their family member. This revision of the law would mean that something good could come out of this horrible tragedy, and that the loss of Brad wouldn't be for nothing. So thank you all for letting me speak to you today, and thank you, Representative Zimmerman.
Sorry for the loss of your brother, and you were very brave and did a nice job of presentation on behalf of your family. Do we have any questions? Representative Pierce.
Thank you, Madam Chair. I'm also sorry for your loss. My condolences.
Thank you.
I was just wondering, when you were talking to the prosecutor about his decision, did he explain why, when the driver crossed the center line, why that wasn't some kind of violation or something that would cause some charges other than not having the license?
Yeah. What happened was his reasoning for the accident was that there was something wrong with his steering. But the prosecutor didn't have enough evidence to prove that he knew that the steering in his vehicle was bad before the accident, like before he left that day or not. There was just, he reported it to the police, but then the body cam footage was lost, so they didn't have that. So when they went back to speak with him, he reverted back and just said, "Oh, I didn't say that. That's not what I meant." So there was just that lack of evidence to prove. Thank you.
Any other questions? All right. Thank you very
Thank
much.
you.
Was there anyone else that wanted to testify? Okay. Representative Zimmerman, if you'd like to close.
Thank you, Madam Chair. I don't like legislating out of emotion. That's unfortunately, that's one of my pet peeves, is legislating on emotion. However, this isn't really an emotional change to the law for me. This is what I find to be an inadvertent omission from the operating without a license statute to add these increased penalties. I appreciate the committee's consideration and ask your support.
Any committee discussion? All right, motion, please.
Move to pass as amended.
Okay, take the roll, please.
Representative McNamara,
Yes.
Representative Gore,
Yes.
Representative Bauer,
No.
Representative Pierce,
No.
Representative Shackelford, Representative Meltzer,
Yes.
Representative Zimmerman,
Yes.
Representative Ireland,
Yes.
Representative Jeter,
Yes.
Representative Bascom,
Yes.
Representative Sturwald,
Yes.
Representative King,
Yes.
Representative Bartels.
Yes.
10-2.
Again, we're going to hold this one open, waiting on Representative Shackelford to return. That's 10-2. All right. Next bill up is House Bill 1416, Representative Bartlett.
Good morning, and thank you, Madam Chair, and to the committee for hearing my bill. House Bill 1416 is a human trafficking bill. I personally think that that's the worst crime that can possibly be committed. And we keep working, trying to get things done that will help. And we have some folks here to testify today on human trafficking. I think in 2023, the United Nations said human trafficking was a $260 billion a year industry. So we must do what we can to combat it. House Bill 1416 simply says that we want to put signage in the restrooms in gas stations. So when the victims, the one time that they get to be by themselves is when they're traveling, is when they go in the restrooms, and they can get this. And as I'm told, even if they take their phones when they go in, they can memorize that number and use it later. So I would ask the committee to support me on House Bill 1416.
Any questions for Representative Bartlett? Okay. We do have an amendment for this bill. I'll turn it over to Representative Meltzer.
Thank you, Madam.
Number 5.
No, number 1.
Oh, amendment number 1. Okay.
There is no number 5.
Different bill, different day. Okay.
Thank you, Madam Chair. Amendment number 1 is a change to the underlying bill to clarify that on the posters for to try to clarify when there is not restrooms in certain gas stations that they need to be placed in two public locations, because we do have gas stations that'll meet the definition that do not have restrooms. And then it also clarifies that the phone number should be the National Human Trafficking Hotline phone number, and that the law enforcement entity should be a local law enforcement agency. And then in addition to those clarifying amendments to the underlying bill, it adds in a requirement for food and lodging establishments and for lodging and for the food establishments is those food establishments that are located on a premises of a lodging provider. So specifically thinking of the motels and hotels that have restaurants in them. And then for those, it also then requires training of staff with a certificate that is to be given to the hotel provider. And it lays out through the Department of Homeland Security that they will set up what those training courses are, as well as work in coordination with the organizations that have produced instructional videos to provide industry-specific training on how to recognize and prevent human trafficking in food and lodging establishments. And this training does already exist and is available to those establishments as an option. So this just is requiring them to start using it and to get that training to hopefully be able to address the situation in hotels and motels where it is likely that this is happening, unfortunately. That is the amendment.
Any questions for Representative Meltzer? There will be folks from the industries to speak to it as well. Representative Bartels.
If somebody does not comply, is there any penalty? What's the teeth in this?
I think it's the same setup as there was for when we did the trucking bill a couple years ago. It's not exactly I'm not seeing the teeth in the amendment. It might be in the code.
All right. Can we take the amendment by consent?
I'll be voting no, Madam Chair.
So are you asking for a voice vote? Okay.
Yes, ma'am.
All right. Those in favor say aye. Aye. Those opposed? Okay. Ayes have it. All right. We will start with Matt Norris from the Indiana Food and Fuel Association. Unless Matt is hiding. Okay. Then we'll go to Abby Rabin with Indiana Restaurant and Lodging Association.
Thank you, Madam Chair and members of the committee. Abby Rabin with TAM Capital Group on behalf of the Indiana Restaurant and Lodging Association. While the underlying bill does not impact us, the amendment does. So we wanted to speak with that, specifically with the training in hotels and restaurants in hotels. First and foremost, as Representative Bartlett mentioned, human trafficking is the worst thing that could happen to a person. So we want to do our part as the industry to inform our employees and make sure that they're aware of what to do and when to call law enforcement. I think that amendment accomplishes that. So through this process, we've worked really closely with the American Hotel and Lodging Association, which is the national trade group representing the industry. What we've really found is that in all states, not just states that statutorily require human trafficking training, hotel brands understand the extreme importance of requiring this training for their employees. And what you'll find is that most of them are already doing so. Many of which you're familiar here in the state, they already have these programs in place. So for some history, Marriott was the leader in developing human trafficking trainings. It kind of became the gold standard. They worked alongside the American Hotel and Lodging Education Institute on what's called the Protect All Children from Trafficking, or PACT website. And then they donated them for free use to anyone who wanted to utilize them. So this is a program that's utilized by many brands across the country. It's a robust training. It's offered in every language that you can think of. And it's typically one of those trainings that get approved by the overseeing agency. As mentioned in the amendment, it fits into those 6 tenets that they have to meet. So this is not a new concept in the industry by any means, and good actors are already participating in a program of some type. This bill would require that those trainings be approved by the Department of Homeland Security, evaluating those 6 tenets I just mentioned to ensure that it's effective and has the proper information. That being said, there are just a few tweaks that we might want to see later on. One being some liability protection for owners that do comply with the law. Something along those lines of indicating that the owner, operator, or employee who complies in good faith won't be liable for any act or omission unless they knowingly assist in human trafficking, of course. And then second, right now the legislation requires that all employees take this training. The way that that's written might be a little bit too broad. It's going to capture those above property employees who never really set foot in a hotel to begin with. So those are 2 changes that we'd probably like to see. And with that, I'm happy to take any questions.
Okay. Thank you for your work on this, Abby, because I know I've been working with you for at least 2 years on
Yeah,
this
it's been a
type
long
of
time.
legislation. I guess the one thing about the liability, which kind of is a concern to me, would be a blanket liability for human trafficking if it takes place on any premises. And I don't want to say it out loud, but I'm going to say it out loud. There are some hotels that, you know, that's their job. That's where they get their money. And I would be opposed to that on those grounds, just because of the idea that some of them just are in that for that industry.
Right.
You know?
And there's some model legislation that I'd be happy to send you that they use in about 12 or 13 other states. And it talks about if you knowingly, willingly, all those magic legal terms, participate in human trafficking or assist in human trafficking, that would no longer protect you.
And what language would you use for the all employees?
I think on-premise employees.
On-premise?
Yeah, I think that would do it.
Would you be in favor of a penalty for not complying?
I would have to speak with my board.
Okay. Sure. All right. Any other questions for Ms. Rabin? All right. Thank you very much.
Thank you.
Appreciate it. Did Matt Norris? Okay. Matt's hiding from us today. Beth White.
Thank you, Madam Chair, members of the committee. My name is Beth White, and I'm the president and CEO of the Indiana Coalition to End Sexual Assault. I want to thank Representative Bartlett for bringing this bill forward. I've worked in the past with Madam Chair on some issues of this type. We stand in support of this bill, of course. Human trafficking is an insidious crime, and one of the worst things is the victims cannot come forward because of their fear when they're being trafficked. And so this is a small way that we can provide information so victims know who to call, what to do when they are ready to seek help. I'm going to yield the balance of my time to some survivor leaders who have come today to tell you their story about this crime and what happened to them. And I'm open to any questions at all.
Any questions for White?
Hi.
Oh, sorry.
Representative Bauer.
Representative Bauer.
Sorry. Thank you, Madam Chair. I was just curious, across the state, how many counties have facilities prepared and ready to assist victims?
All of our rape crisis centers around Indiana, and there are 16 certified rape crisis centers, are prepared to receive victims and to help them. There are other service providers, about 7 or 8 additional. So we do have a network of places. The problem, Representative Bauer, like in so many cases, is where there can be safe and housing for these particular victims. We work with law enforcement, with the U.S. Attorney's Office, and with our federal partners to try to find a safe place for victims to go. But it is so hard to find safe and affordable housing for victims.
Thank you.
Questions? All right. Thank you very much.
Thank you.
Jessica Kern.
Hello, thank you, Madam Chair, and thank you, Representative Bartlett, for bringing this legislation forward. I am the president and founder of a not-for-profit that provides education to law enforcement and healthcare agencies and schools and different agencies across the state of Indiana and across the Midwest. It is a new not-for-profit foundation, but the reason that I started this foundation is I am a human trafficking survivor. I was trafficked for 14 years in the state of Indiana. The average life expectancy for a human trafficking victim is 7 to 8 years. I survived 14 years of that, and I was one of the very few that were lucky enough to escape. I didn't come forward and tell my story until I was 30 years old, and I'm now 44, because it was not safe for me to come forward. Even though, as of now, there are many facilities across the state of Indiana that are growing, there's not enough. And there's not enough legislation on the books as of right now that protect victims. The legislation that Indiana has on the books is perpetrator focused. There are a few, and there are a few champions that are trying to change that to protect victims, to make it safer for us to come forward. This is a huge step in the right direction with this legislation. A lot of times when these children are trafficked, the only time that they are alone is in the restroom, and they are very aware of their surroundings. Speaking from direct experience, I can tell you that I would memorize road signs, I would memorize numbers, I would memorize everything that I could and try to find a chance to escape. And it's very difficult to escape those types of situations. If there would have been signage in some of those truck stop restrooms, then I would have memorized that number. There are programs in Indiana, which I'm sure Matt will speak to, such as In Our Backyard, that already offer stickers. The problem is that until now, it's not mandated. There needs to be some type of mandate that says that this signage needs to be posted within these places that sell commercial fuel. We are happy, our organization is happy to work with any of those other organizations to take the burden of finance, like the financial burden off of the committee for this bill, if that ever arises. We offer our services for free and try to raise awareness within the community. When I came forward and started telling my story, it was very hard, and my name has changed and I have moved. And I don't mention names, but I tell my story publicly. But I will tell you before this committee that the main handler in my trafficking ring was a sitting judge in the state of Indiana. And I don't say that to promote fear. I say that to where the handlers in these trafficking rings are very affluent men. Representative Bartlett alluded to the fact that it's a $260 billion a year industry. That was true in 2023, but currently it is $276 billion. The average cost per child is $93 an hour, and trafficking victims have between 8 to 10 sexual partners a day. And these are children. And we are working tirelessly with our agency and agencies like ours across the Midwest to try to at least save one or two of those lives and do everything that we can. This is something that people don't like to talk about, or people don't think that it's happening in Indiana. But according to the FBI database, Indiana is currently the second largest state in the nation for human sex trafficking. The numbers are huge, and Indiana has a conviction rate of below 2% for these perpetrators. So even though this bill doesn't speak quite to those things, this bill is a step in the right direction. I always use the analogy when I'm talking to supporters or when I'm talking to representatives, as you have met with some of you, I always use the analogy of they're like, well, what do we do? If you're a thief and you go into a store, are you going to go into a store to steal something in a store where there's a lot of cameras or a store that has no cameras? This bill is one way we can put a lot of cameras up. These traffickers are not going to risk billions of dollars and risk getting caught if there's signage, if there's stuff up, that will deter them. So again, I thank you so much for your time, Madam Chair and committee. I thank you very much for allowing us to be here today. I turned my story into a way to try to raise awareness within the community as much as possible and to try to help. So again, thank you, Representative Bartlett. Thank you, committee, and I would be happy to take any questions.
Thank you very much. Any questions from the committee? Okay. Thank you very much.
Thank you very much.
Alice Cross.
Hello, thank you very much for having me. My name is Alice Cross. I'm the treasurer for Raindrops Rising Foundation. We're a nonprofit, and I am a sexual assault survivor, childhood sexual assault survivor of family members. So I'm not a human traffic survivor, but I get the point. I've been through the trauma. and it's a healing process every single day. So if there's one person that we can save by just a sign in a bathroom, that's what we need to do. Just one person a day or just one person a week. I don't care, just one person. If we can save a child or even a young adult that's going through this, they deserve to be saved. They deserve to have their life fulfilled, to get turned around. Like us at Raindrops Rising, we have turned our lives around. This is where we are now, and this is what we are doing. And so this would help a lot. So just thank you.
Any questions?
Yeah.
All right. Thank you very
Thank
much.
you.
Appreciate it. Evan Weimer.
Thank you. My name is Evan Weimer. I'm the Executive Administrator for Raindrops Rising Foundation. According to the Attorney General of the District of Columbia and U.S. Immigration and Customs Enforcement, human trafficking is the second largest crime industry in America. Selling humans is one of the most profitable crime industries in America. This is modern day slavery. Typically, the only time that trafficked persons are alone is when they're using the restroom. These individuals are attentive, and there's a high chance that they'll remember that phone number. Even if they don't call right away, the moment that they're alone with a phone, they'll remember that there's someone out there who wants to help. This bill is not a solution. It's a step in the right direction. We're looking for support, and we're wanting a step in the right direction. That's what we do every day, is that we're just looking for, like my coworkers have said, we're looking for help and support.
Any questions? All right. Thank you, Gus.
Thank you.
And thank all three of you for sharing your stories and being brave enough to come speak. Matt Norris, come on up.
Thank you, Madam Chairwoman and members of the committee. Matt Norris with Krieg DeVault here today in my capacity as the Public Policy Counsel for the Indiana Food and Fuel Association. Apologies for not being here earlier. Just wanted to offer a few comments. Certainly appreciate Representative Bartlett bringing this issue forward and bringing attention to the issue. For those that testified before me, my heart goes out to them. Had a chance to talk to them outside and wish them well. And I would say that the industry is happy to partner with them in moving forward and bring more attention to this serious issue. Indiana Food and Fuel Association actually has partnered with the In Our Backyard campaign. We launched a public awareness campaign back in 2018 to bring more attention to this issue and to encourage our members to be mindful of and to watch for instances of human trafficking. And I just had a chance to poll our board members and had several of our board members that have said that they still participate in the In Our Backyard campaign. They have stickers in their bathrooms that provide information to individuals that are going through that situation, including numbers for the National Human Trafficking Hotline. I suppose going forward, I'd like to, and I spoke to Representative Bartlett about this, possibly work on the language. I know the bill requires the posters to contain certain information. My members that are already doing something in this area, the stickers don't contain all of that information, but they do contain some important information. So if we could have some maybe flexibility on what's required, I think that may be a good way forward. I also offered to them that we host an industry summit every fall where we have presenters come in on a variety of topics. I think this would be very appropriate for the prior individuals to come in and speak about their campaign and their program and how they can partner with our industry. So again, just some sort of general comments. A lot of our members are already doing things in this area. We're happy to do more, and perhaps just some flexibility on the requirements of the posters might be warranted. But with that, happy to take any questions, and thanks for your time.
Any questions? Representative Bartels.
Thank you, Madam Chair. The issue of employees are brought up. Do you think there should be some employees that are exempt, like somebody that's an online marketer that's never in these facilities? Is there a list?
Well, I don't have the language in front of me. My understanding is there's no specific requirement for the employees in the convenience store setting, the gas station setting. I think that applies to other establishments. I really can't comment on that. I was remiss, and we talked about the In Our Backyard campaign. A component of that is training for employees. So I would be concerned if there is a mandate on all of our employees to be trained. We'd have to probably have some conversations about that. The language I've seen, I didn't see anything that would mandate that for employees in the convenience store setting. But I would say voluntarily, a lot of our members are already doing that.
Any questions? All right. Thank you very much.
Thank you.
Okay. Representative Bartlett, that would you like to close? Come on up here.
I'm one who believes that you can talk too much and mess up what you already got. But I think you've heard from the victims, and what we're trying to do here is to assist someone who is really in dire need. So I would encourage a vote yes on this House Bill 1416. And thank you, Madam Chair, for the opportunity.
Thank you very much. Are any comments from the committee?
Move to pass as amended.
Second.
Take the roll, please.
Representative McNamara,
Yes.
Representative Gore,
Yes.
Representative Bauer,
Yes.
Representative Pierce,
Yes.
Representative Shackelford, Representative Meltzer,
Yes.
Representative Zimmerman,
Yes.
Representative Ireland,
Yes.
Representative Jeter,
Yes.
Representative Bascom,
Yes.
Representative Sturwald,
Yes.
Representative King,
Yes.
Representative Bartels.
I think we still need to do some language on this as far as employees and verify what the penalties are. So until we get that cleaned up, I'm a no.
11 to 1.
Okay. Right now it's 11 to 1. I'm going to hold it open again for Representative Shackelford to come back. All right. I noticed some folks signed up to testify. We are not going to be taking testimony on the rest of the bills. They are amend and vote only. What will take place is the author of the bill and anyone who has an amendment will be the ones that will be speaking. So we're going to start with House Bill 1677, Representative Gore.
Thank you, Madam Chair. Thank you, members of the committee, for your consideration today. This bill seeks to address an issue that is serious and getting worse in my community, and I learned that it's a serious issue and getting worse in communities across the state. I represent mostly a suburban district, and it's a big deal. It's obviously a big deal in urban settings, and I've learned more and more that it's a serious issue in rural communities, and that's the issue of illegal dumping. Especially in rural settings, people dump on the back 40 of somebody's farm, and it's left to the property owner to address it. And as I scoured the Indiana code to kind of ascertain what my local units could do to address this issue, there really isn't much. My communities have ordinances surrounding illegal dumping, but that becomes a civil matter. And actually in my communities, code enforcement will come out and cite the property owner when they get dumped on. And then it's up to the property owner to file an affidavit saying, no, this was illegal dumping. Please don't fine me. And then luckily my communities have a program whereby the municipality will help them clean that up. And I didn't think that was that system was quite right. So this bill says if you're an individual who dumps a large quantity of material or repeatedly dumps illegally, you could be charged with a Class C misdemeanor, the lowest level misdemeanor, just above, almost the infraction that it would be now in local communities. Just seeking to provide one more tool in the tool belt for locals. It doesn't preempt them from following whatever process they have now. But if a community decides that illegal dumping in general is a serious issue for their community, or if they have individual instances of dumping that they think would warrant a law enforcement response, not just a code enforcement response, they would now have that option. That's the gist of the bill. Very grateful for your consideration.
Any questions for Representative Gore? And I guess I should have mentioned these bills that we're going to hear, the next three, all have been through another committee already. That's why we are not taking any testimony.
And in that vein, Madam Chair, I would just mention that passed out of Environmental Affairs unanimously.
Okay. All right. I interrupted. So Representative Pierce.
Actually, I just had a comment about this process. So I know that in Ways and Means Committee, when they get a referral, nothing holds them back. So they'll rework the bills if they want. But is it the sense of the chair that our job is to mainly focus in on the penalties to see if they're proportionate? Is that kind of what we're supposed to be doing?
it's the intent to look at the entire policy of the bill that comes forward of us. Sure. Okay. Any other questions pertinent to this? Okay. Oh, sorry. Representative Jeter.
Representative Gore, are you familiar with the case Morissette versus United States?
No, I'm just a poor old cop from the southeast side of Indianapolis.
Well, it's a 1952 Supreme Court case about illegal dumping. I would commend it to your reading pleasure.
Morissette v. what now?
On that note, can we please
Versus United
have a
States.
motion?
Move to pass.
Representative McNamara.
Yes.
Representative Gore.
Yes.
Representative Bauer.
Yes.
Representative Pierce.
Yes.
Representative Shackelford. Representative Meltzer.
Yes.
Representative Zimmerman.
Yes.
Representative Ireland.
Yes.
Representative Jeter.
Yes.
Representative Bascom.
Yes.
Representative Sturwald.
Yes.
Representative King.
Yes.
Representative Bartels.
Yes.
12-0.
Right now, this bill's 12-0. Again, I'll hold it open for Representative Shackelford. Representative Bartels, House Bill 1186.
Thank you, Madam Chair. So I'm sure this is the first time anybody's heard about 1186, so I'll go through as fast as possible. But so the gist of it is here is we can start with page 11. Section 2 will be addressed by Representative Gore's amendment. There was an agreement from all the stakeholders. Additionally, on page 11, we're actually taking the correctional professionals, officers, police officers, and employees of the Department of basically the gist of this bill when we're talking about limiting some police powers for SROs, special deputies, and reserve officers. I'll talk about that a little bit more in a minute. But basically, the gist of this is a tier 1, tier 2 trained officer in the state of Indiana. There's no changes. They can do whatever they want. If you fall in that category of an SRO, special deputy, or reserve officer that does not have that tier 1, tier 2 training, there's some limitations. I think that all the parties have kind of agreed. When I say that, the reserve or the SRO Association, the FOP, the Indiana Sheriff's Association, Indiana Chief of Police Association, and the Indiana Marshals Association, I believe we kind of blanketly gave these powers back in certain instances. So the limitations would be this: if the officer that has less than that tier 1, tier 2 training is in their jurisdiction, nothing changes. Whether they're off duty or on duty, they can wear police insignias and do anything in the scope of what their department allows them. If they're going to leave that jurisdiction, they can do so if they're in the pursuit of, if they're doing investigation work, if they're traveling to and from work, the transportation, if they've been dispatched. I think where the issue comes in is when one of these categories is trying to work off duty, and the issue is wearing the insignia of police. I think that the public and other officers have an expectation that if you have the word police on it, you're trained to some standards. And a lot of the public doesn't recognize or understand that currently a special deputy, a constable requires zero training. A reserve officer in the state of Indiana is required to have 5 days of training and then 24 hours in service training every year after that. So what this bill does is say they can operate and wear police insignia for off-duty jobs outside their jurisdiction if they get an MOU, just an understanding with the next higher law enforcement authority that says, yeah, you can do this. You can do this in our district. There's a lot of reserve departments or officers that have gone through some robust training. It's probably comparable to the academy, but I think that's up for the law enforcement community that they're going to be working in to determine, yes, you can come and wear that. It does not stop them from ever wearing security. So they can go outside and wear security. So there's some issues that are brought up that, some of these events that need a lot of officers, they can still do that. They just got to get an MOU to understand that, or wear security. So that's just that part of the bill. If we go here, we did change some things that were the SROs. There are some SROs. Most of them, pretty much all of them, are almost tier 1 trained. There are some instances where a department will basically deputize somebody to be an SRO. So we made sure they realized that all SROs that have tier 1 training have statewide jurisdiction. And if they don't, then it's all in the same category as the other ones. Madam Chair, the other thing is we want to talk about on page 18, where we're enhancing penalties for criminal recklessness, and trying to change those to match what's happening throughout the state. Is there's a lot of aggressive driving, reckless driving, and with a firearm, and pointing firearms and shooting firearms. Representative Pierce, I kind of mentioned, I think that Madam Chair is going to hold this until we can look at these enhancements. So I think that we can get that kind of right if we want to move the needle on that. There is one amendment that I would like to present, is number 7, if I could, Madam Chair.
Go ahead.
So this is actually an omission. It was actually voted on and vetted in the Veterans Affairs and Public Safety. So we want to make sure that what this basically says is, in code right now, an SRO cannot pursue a person who's fleeing. We tried to find out why that was in there, and all we could figure out is they took the language from another state and it had it in there. So we want them to have the same police powers based on their training. So we want to add that back in there and make sure that an SRO can pursue somebody that is fleeing from them. So that's all that does on the amendment.
Any questions about the amendment? Representative Pierce.
Yeah, so Representative Bartels, just to clarify, so what kind of training do they need to have to be able to have their powers offsite and pursue people? Or
so any officer, if they're operating in their jurisdiction and they leave their jurisdiction in pursuit, there's no changes. They can do that. Yeah. It's on page 15. We've kind of covered everything. The big thing was a lot of pushback was, well, if I'm driving somewhere and I see something. If you look at line 40, exigent, I wouldn't always get that wrong, like cinnamon, circumstances, kind of, if you look at that in the code, that kind of gives them the authority to intervene. If they see somebody weaving, they can still stop somebody. As long as they adhere to the other things like proper attire that they wear with the notification of police and their badge, and also the requirements of the vehicles too. So
I guess what I was trying to figure out, I mean, it makes some certain amount of sense that you would want to be able to pursue people that start out in your jurisdiction and keep going. On the other hand, if you got a high speed chase going, you want to hope that officer is really well trained in that technique and when to back off and all that kind of stuff. So I'm just trying to figure out how that training might match up with the potential action.
Great question and point, Representative Pierce. The issue is we don't know what the reserve officer training course is, right? Because they're different. So I think it's up to the sheriff or the chief of police or the other agency to say, look, we kind of know what you guys have been trained. We're good. You can come in here and do whatever you want. That just gives them the complete power. But if there is a department that does not have the resources to train reserve officers other than that 5-day training course, I think this gives the next higher law enforcement agency the opportunity to say, hey, look, no, we have a policy on hot pursuit. We have a policy on de-escalation, and maybe they can work that out. I think that's what we're trying to do here is we're just like, look, we want to make sure that officers are going to operate outside their jurisdiction or trained to the standards, or at least an understanding that who they're going to be working with. And if I'm in a situation and I see police on a uniform, I have an expectation that they know how to help me, whether it's detaining, search and seizure, probable cause, and those kind of things. So that's the intent.
To clarify, an SRO has to have tier 1 training regardless?
To be certified, yes.
Okay. So I'm trying to clarify. Yep. Your question was in response to the SROs, correct? All right. So they would already have that training necessary. Okay. All right. Any other questions in regards to the amendment? Okay. Can we take that by consent? Consent. Okay. Any questions about his portion of the bill for Representative Bartels? Okay. All right. You have a question?
I do.
Okay, great.
Thank you.
Representative King.
Thank you, Chairman McNamara. Representative Bartels, I just have a couple of questions for clarification. If, when the Elkhart County 4-H Fair has their big event and we bring hundreds of thousands of people to our event, and we have officers coming from other jurisdictions, you're saying that an MOU is all that would need to be required to suffice what you have in this bill. Is that correct?
Only for those officers that have, or either constable, special deputies, or reserve.
Okay.
Anybody with tier 1, tier 2 trained, full-time officer, so to speak, there's nothing needs to be done.
Okay, so memorandum of understanding can take place. I mean, you know, a little bit of a, not a huge process, but have you considered what happens during, like, let's say a search and rescue, or like something that's maybe more of an emergency basis, and you're pulling like mounted police from one county to another? Does this bill at all talk about that in any way? I mean, when it's an emergency, do you have time to do memorandum of understanding? And I don't know, I just want to make sure that we're not handcuffing, especially rural communities.
Yeah, I'm going to get this word wrong again. So yeah, that's been vetted through the community, and under exigent circumstances that would be covered. I don't know why I can't do that word.
I think you just need to keep making him repeat that.
Yeah, I
word.
know. Thanks.
Thank you.
Okay. All right. Any other questions for Representative Bartels, or make him say that word? Okay. All right. Representative Gore, you have an amendment as well?
Thank you, Madam Chair. I do. I appreciate the consideration. When this was in Veterans Affairs and Public Safety, we wanted to address, because the underlying bill is kind of delineating those officers who are tier 1 and tier 2 certified and those who are not. It didn't contemplate, and this happens all the time, the very peculiar situation that exists in Marion County. And so Marion County is the only county, to my knowledge, that has full-time regular sheriff's deputies who are neither tier 1 nor certified, nor are they special deputies. And so to ensure we could fully comply with the spirit of Representative Bartels' bill, we inserted some language that says, okay, for these 300 people, we're going to, because they've completed the necessary training, we're going to certify them so that their normal duties can continue. And then it codifies what is current practice, but hasn't always been. And that's that for new hires in Marion County going forward, they'll be admitted to the Indiana Law Enforcement Academy in the same manner and proportion as all other agencies. So it fixes the incumbent deputy issue that was kind of inadvertently posed by the underlying bill, and then the issue with new deputies going forward. We then got together with some stakeholders, and we just made a few changes to certify these folks as tier 2, not tier 1. There may be a few subjects where the Indiana Law Enforcement Training Board wants, like, maybe a little bit of continuing education or a little bit of bridge training. So that was a compromise there. And then just to ensure that they're fully considered by in the provisions of the chapter, we included them specifically in the definition of law enforcement officer up above, where otherwise they had not been. So that is this amendment. And I just mentioned, for any of them watching or present, really grateful for the stakeholders' work on getting this in a good spot right now.
Any questions for Representative Gore? Representative Bartels?
Just more of a statement, Madam Chair. During this meeting, I just want to verify too that we really discussed the opportunity of the academy to start considering this bridge concept. We do have a lot of reserve programs out there that are robust and probably exceed the tier 2 training at least. So I think that they've been open to at least, not probably this session, but at least have a consideration of how we can start looking at certifying, at least at some level, some of these programs out there that are excellent.
All right. Any other comments or questions? All right. Can we take this amendment by consent? With a little more enthusiasm. All right. Any committee discussion? All right. Representative Pierce.
So are we going to hold the bill to work on the penalty stuff as well?
Thank you for reminding me. We will be holding this bill according to the reminder given me from Representative Pierce. And then we'll save that for next week, which moves us to the last bill for today is House Bill 1412, Representative Cash.
Thank you, Madam Chairwoman and members of the committee. This legislation does three things. First, I want to mention that this bill passed unanimously through the Committee on Children and Family, both last year and this year. So first, the legislation would increase the penalty for failing to report knowledge of child abuse in sports, schools, and other institutions and organizations. Many of you are likely aware of the gymnastics sex abuse scandals that have rocked our country in Indiana. As these stories played out, we learned that USA Gymnastics, based out of Indiana, had not only failed to make reports, but had actually told coaches and gymnasts that they would handle the accusations. USA Gymnastics does not just govern world-class gymnasts, but also our young boys and girls at gyms across the country and Indiana. It was clear that despite being mandated reporters in the state, these reports had not been made and many young lives were devastated. A question remained: if we are all mandated reporters, where was the fallout for those who knowingly failed to make the reports? We have sadly had multiple gyms in Indiana have coaches convicted of abusing our athletes. We have also had teachers, music instructors, and even a pediatrician in my community arrested and convicted of sexually abusing. In some of these cases, it became apparent through investigations that staff members knew of the abuse or had been told there were issues, but did nothing, not even putting the staff or coaches into administrative jobs while reporting for investigation. Failure to report affects every child in every gym, club, or institution. HB 1412 will raise the penalty for failure to report knowledge of abuse in facilities to a misdemeanor A. It's currently a misdemeanor B, which carries a fine of up to $5,000 and 18 months in prison. In addition, county prosecutors tell me that law enforcement does not have the authority to investigate whether an entity failed to report knowledge of abuse. Therefore, this legislation clarifies that if the Department of Children and Family Services determines that a child in a facility has been abused, they are to notify law enforcement to investigate the facility for failure to report. And if law enforcement concludes this to be the case, make a full report to the county prosecutor. Second, this legislation fixes inconsistencies in Indiana code as it relates to who must report suspicion of child abuse. Indiana law says that every person over 18 in Indiana must report. That includes every adult currently in the State House and in this room. However, as I worked with attorneys, professionals, and state agencies on this legislation, I learned that the Indiana code has a bit of a discrepancy when it comes to health providers and staff in medical facilities and hospitals. There is currently an exception in the law, IC 31-33-5-2.5, that says that doctors and staff of a medical facility may delegate their responsibility to report to DCS or law enforcement. No one else has this exception. And I know there's going to be an amendment that's going to be coming to kind of try to fix that. You may hear that it's too burdensome. Oh, actually, I'm going to skip that part. So, because I think we're going to fix that here. So anyway, happy to take any questions. And I do believe that Madam Chairwoman and possibly Vice Chair have amendments.
Any questions for Representative Cash on the bill itself? All right. Thank you very much. All right. Representative Meltzer has amendment number 5. Is that correct?
Yes, amendment number 5. Thank you, Chairwoman. So amendment number 5 goes in and tries to clarify the situation where possibly delegation would be appropriate. Being a mom to 3, I've worked into a hospital located pediatrician's office for the last 8 years when it moved. And that meant that in every single well child visit, I encounter at a minimum 4 to 6 different providers that would fall under the care team to report, and to have pediatricians and nurses and social workers and potential medical assistants all calling DCS immediately seems redundant, not only for those medical providers, but also redundant for DCS. And so this amendment is to address that. So what it does is it states that it can be delegated so long as when you are delegating it, it is in writing. So if you are going to delegate it to a specific person, you have to do that delegation in writing. The person to whom it is being delegated is then to make the phone call to DCS. They are also to go in and to the medical file and note that they have made that report to DCS so that all medical providers are aware that this has been done. It also clarifies that not only are they to state that they made it, but the date, the time, what they reported. And so therefore, if a medical provider were to read it and say, no, actually more should be told to DCS, they will know that they need to make an additional phone call. And then it also goes in and it states that if you are failing to make your report as required, it can increase on the second offense to a level 6 felony. So really trying to state that it's extremely important that we are calling DCS when we suspect child abuse or neglect. And then there are other cleanups to make sure that we're reporting to the appropriate law enforcement agency, not necessarily the local. Depending upon where this child is being seen, the local law enforcement agency may not be the appropriate agency to call. And that is what amendment number 5 does.
Any questions for Representative Meltzer on the amendment? Representative Pierce?
Yeah, so it looks like you're also enhancing, I guess, the failure to report. So could you just explain what you're thinking on that?
My thinking on this is that if someone has the duty to report child abuse and neglect and they are failing to do so and they pick up in a misdemeanor and they continue to fail to make that report, a level 6 felony seems appropriate to me.
Any other questions? Representative Gore?
And just to, I want to be clear because I'm not an attorney. It has to be intentional, right?
Yes, it's a crime, so there'd have to be intent.
Okay. Oh, that's right. Morissette v. U.S. did hand down the decision that intent is inherently part of the act, and the finder of fact has to make that determination. I forgot. Thank you.
Well, I was gonna, quote the word of the day, and since we've had 2 words of the day, asinine and exigent, but let's move on. Any other questions for Representative Meltzer? Okay, can we take this amendment by consent? Consent. Okay. Any other further discussion on this particular bill? Can I have a motion, please?
Second.
Go ahead.
Representative McNamara.
Yes.
Representative Gore.
Yes.
Representative Bauer.
Yes.
Representative Pierce.
Yes.
Representative Shackelford.
Yes.
Representative Meltzer.
Yes.
Representative Zimmerman.
Yes.
Representative Ireland.
Yes.
Representative Jeter.
Yes.
Representative Bascom.
Yes.
Representative Sturwald.
Yes.
Representative King.
Yes.
Representative Bartels.
Yes.
13-0.
Bill passes 13-0. We need to go back and get Representative Shackelford's before we can adjourn. So we'll start with House Bill 1006.
No for that one.
Tell me when you're ready.
I'm going to record on paper and then put it in.
Okay. House Bill 1114.
No.
House Bill 1416.
Yes.
And I don't remember where we left off. House Bill 1677.
Yes.
And then you voted on this one, so we're good to go. All right. With that, I think we are adjourned. So.
All right, ladies and gentlemen, that was that. Listen, I've got to say, this was very frustrating. Today was a frustrating day. This is it's just not good. It seems like they're holding the bill over to work on penalties as it results from the driving through construction zones recklessly and or using a gun while doing that. So that's unfortunate. It's a sad thing. But listen, it's still a plus. They did not vote. They did not pass this. So anytime you don't lose, it's a win. We still have time to talk with these people to try and let them know that they work for us. It's time to do what the people are saying. My biggest issue is I still don't think that they have a clue what's going on. And the worst part of this is Bartels was a cop and Gore is still a deputy. And so it's very frustrating. And, I don't understand what's going on here. They keep talking about constables and special deputies. Get rid of the whole idea of the constable and get rid of the whole idea of the special deputy thing. Special deputies, that's a nonsensical thing. It is something that was a holdover from the sheriff's departments of the 1800s when the sheriff would deputize people and we could go out as a posse to pick some people up. We don't need to do that anymore. The special deputy is now given to people as political favors and whatever. And I do believe that's a problem because you now have given this person a badge and an ID. Listen, if somebody gave me a special deputy badge and ID, you know what I would do with that? I would put that up on my wall in my shadow box with the badges that I actually wore when I was on the police department. I would put that with my other law enforcement memorabilia. I would never carry it. I would never think, oh God, I'm a cop now. But there are idiots out there that do that. And so write a law that deals with that. Write a law that ends the special deputy situation. Write a law that says that a sheriff can hand out a quote unquote special deputy, but there's no actual authority to that. You can deal with all of that stuff. Still, you don't have to do this. I feel like there's a lot of misunderstanding about what's really going on here. And the other thing is, it sounds like this whole thing is about off-duty work. If you want to talk about off-duty work, deal with that. Leave this bill alone. I don't know. But I've got a lot more to say about this. Tune in tonight. Tune in tonight at 9 p.m. right here, the Political Spotlight. We're going to be talking about this and a lot more on tonight's show. Tonight at 9 p.m. Eastern, right here, the Political Spotlight. I don't have the link up. The link will be up a little bit later. Look for that. It's here on YouTube, Facebook, X, and Rumble. So check that out. We'll be on at 9 p.m. tonight. Until then, you guys be safe. Take care. God bless each and every one of you. And we'll see you tonight at 9 p.m. What a day. I'm going to go get something to eat. You guys take care. And we'll go from there. And hey, listen, if you're an American citizen out there, exercise your Second Amendment and carry properly and do what you got to do. Take care. Good night. God bless. Well, it's not good night, but we'll see you tonight. Bye.